If you're watching this, you or someone close to you may be dealing with a domestic violence charge in Colorado. That can be overwhelming, confusing, and scary. Hi, I'm Clifton Black, founding partner with Black, Blink & Associates. I have been practicing criminal defense in Colorado since 2000. My goal is to help ease the confusion by explaining what domestic violence means under Colorado law, what's at stake, and what options are available to you.
What is domestic violence?
In Colorado, domestic violence is defined as an act or threatened act of violence upon a person with whom the accused is or has been involved in an intimate relationship. In practice, domestic violence can include any other crimes against a person or property if the crime is against someone you had an intimate relationship with and the crime is committed as a method of coercion, control, punishment, intimidation, or revenge.
What does an intimate relationship mean?
Colorado defines intimate relationship broadly. It can include relationships between current or former spouses, people who are currently dating or used to date, or people who share a child together. This means any of these relationships can be the basis for a domestic violence charge.
What kind of consequences does a domestic violence conviction involve?
If you're convicted of domestic violence, it can come with a multitude of different consequences, depending on the circumstances, including jail time or prison, fines, restitution to the victim, meaning you may have to pay the victim to compensate them for the damages caused. There's also court costs, among other things. Any conviction for domestic violence will include a mandatory domestic violence evaluation and completion of domestic violence classes. There can also be life-changing consequences.
Are there any long-term consequences people may not be aware of?
Besides fines, restitution, protection orders, and the possibility of jail time, if you are convicted of domestic violence, you'll lose your right to own a gun and ammunition. That's not all. Family courts consider these convictions and may limit or revoke your parental rights. If you're a non-citizen, it can also impact your immigration status and result in deportation. Most concerning, domestic violence convictions will appear on criminal background checks, which may cause you to lose your job, impact your ability to find a job, impact any security clearance you may have, and even renting a home. In many cases, a domestic violence conviction cannot be sealed or erased from your record. That's why it's important to understand the full picture, not just the immediate charge.
What kind of prison or jail sentences are there for domestic violence convictions?
Generally, for a domestic violence charge, a prison sentence is unlikely unless you have multiple prior convictions or there is a very serious felony conviction as well. If there is sufficient circumstances for a judge to issue a jail sentence, generally you will be looking at up to 18 months for a misdemeanor domestic violence and potentially decades in prison for felony domestic violence involving serious incidents.
Will there be a protection order?
Yes, in any domestic violence case, the court will impose a mandatory protection order against you at the outset of the case in order to protect the alleged victim. The mandatory protection order requires the person not to harass, intimidate, threaten, retaliate against any victims or witnesses, requires the defendant to vacate the shared residence, and prevents communication with the alleged victim. As an experienced attorney, we know the best way to convince the judge to modify the protection order. We try to get it modified so that our client can get back in the household and can have communications with their spouse or significant other.
Does the protection order ever go away?
Yes, the automatic protection order goes away once the case is closed. However, in many cases, the alleged victim may also apply for a permanent civil protection order, which is separate from the mandatory protection order from the criminal case. If that is granted, it may never go away, so you'll want an experienced attorney to help you fight it.
What if you have multiple domestic violence convictions?
Having multiple domestic violence convictions can be a big problem. 3 or more prior domestic violence convictions can result in a new DV charge to be elevated to a Class 5 felony, which results in much harsher penalties, including state prison time.
What underlying charges do you typically see in a domestic violence case?
Domestic violence typically involves charges of harassment, which can include obscene language, gestures, repeated phone calls, texts or other messages, and even physical contact like shoving and kicking. It can also be misdemeanor or felony assault charges, criminal mischief or causing property damage, which can be a felony if the damage is over $2,000, phone tampering, which can include preventing somebody from making a phone call or taking the phone from them, false imprisonment, which is generally preventing an alleged victim from leaving an area, or kidnapping, which is moving a person from one location to another location.
What defenses can I use for a domestic violence charge?
It's important to remember a charge is not a conviction. There are multiple defenses that you can use against a domestic violence charge, including general denial, it never happened, self-defense or defense of property, or lack of intent. For a valid claim of self-defense, you must show that you reasonably believed you were in imminent danger of unlawful physical force from the alleged victim and that you only used the amount of force necessary to protect yourself. There may be other defenses available. It's important to seek help from an experienced attorney who knows what defenses are relevant to your case and how to effectively attack the prosecution's case.
Is it common for people to be falsely charged with domestic violence?
Yes, we see this often. False or exaggerated allegations do happen, especially in the heat of the moment during an argument, or like in a contentious divorce or child custody battle. A good defense attorney can expose a motive for the false report, such as revenge, gaining an advantage in family court, and can challenge the accuser's credibility by highlighting inconsistencies in their statements, any history they may have in making false claims, or their motivation for doing so. Because of this, we do get a lot of domestic violence cases dismissed.
What does the prosecution have to prove?
The burden of proof rests entirely on the prosecution, which must prove beyond a reasonable doubt. Many domestic violence cases rely primarily on the testimony of the alleged victim. If there is little physical evidence, or if the testimony contains inconsistencies, a defense attorney can argue that the prosecution has not met its burden of proof.
Anything else I should know about domestic violence charges?
Domestic violence charges are serious, but remember, you're not deemed guilty unless and until you are convicted. With such high stakes, it is vital that you seek the help of a qualified attorney with experience defending against these types of charges as soon as possible. If you're facing something serious, you don't have to handle it alone. We're here to explain your options, protect your rights, walk you through the process, and help you move forward.